49L, the 17th of the 11th 2022, the 17th of November 2022. Environmental protection. It was guaranteed in the founding treaties of the European Union. I'll give an example of a public house. If you wanted to open a public house on a greenfield site at some particular location, let's say it's the Fair of Muff site here in near Kingscourt in Cavan, or some other famous place, or at the Battle of the Boyne or something, you would have to get a field or get a building. You would have to buy a license and buy another license. You'd have to extinguish one license and transfer the other license, or you'd have to apply for a whole new pub license from the circuit court, and there'd be a whole big long process in that, in which the fire services, local people could give their opinion, and all of that would be taken into account before you could even get approval for a pub license on the site. So not until you get the certificate of suitability of the premises and all of that can you then apply for a public house license, the same as if it was there for the last 100 years. You can apply each year to the licensing court in the district court. But the process for getting your pub established in the beginning, your building as a pub, goes in the circuit court, and there's a lot of law and a lot of expense attached to that. In practice, an odd new pub opens up using licenses that are quenched or extinguished from 2 other pubs locally, or whatever the law is in that. So if you come along then, and if you come along and you start selling drink in a shed, in a field, or on a building, or at your own house, or down in the hay shed, and you have a big hoolie going on, drink flying, dancing, everything, and the Gardaí, the police or whatever come in and they raid you, they can only prosecute you for having no license, for running a shebeen or an unlicensed drinking premises. You could have children on the premises illegal, they can do nothing. You could be operating gambling on the premises, they can deal with the gambling, but they cannot deal with the fact that it's a pub. It's not a pub, it has no status as a pub, it's a private building. Okay, once it's licensed, then it is a licensed premises, and it can be all the rules, including COVID lockdown, applies. So for essential, if you had an unlicensed pub and you ignored the COVID lockdown, you couldn't be prosecuted under the rules there. You might be prosecuted under other things, but you couldn't be prosecuted for having a pub open, a wet pub, when in fact it's not a licensed premises. I think you get that idea. So the rules on the licensing of the premises is the overarching rules, whereas the rules on the local administration is to the district court. The rules on the licensing of the premises is with the circuit court, a higher court. The rules with the district court is for the ordinary pub. So you're drinking after hours, the guard takes your name, you're fined €25 in the district court. You go to the district court every year to get your license renewed, and you produce a certificate from the Inland Revenue, or the Revenue Commissioners, to say that you're compliant with tax, and away you go. In environmental cases, the Strategic Environmental Assessment Directive 2001/42 EC deals with the overarching plan or programme for energy, agriculture, fisheries, forestry, tourism, town and country planning, river basin management, or any other industry set out in the annexes, which include things like smelting, nuclear power stations, thermal power stations over a certain size, piggeries over a certain size, pig hatcheries over a certain size for poultry, and all of that sort of stuff. Okay, so if it's in there, you have to, and as part of a government plan or programme, you have to have it assessed under the SEA. Now, if a company wanted to set up a smelter above in Navan beside the mining, that would come under mining. So that might not need an SEA, provided it's not part of an overarching plan or programme. Going to energy, the Renewable Energy Action Plan, all these windmills, pylons and all that, that is an overarching plan or programme for energy and should have been assessed, and it wasn't. Okay, now, if that had been done and there was an assessment carried out under the SEA directive for the planner programme, public planner programme, then all the other things built would be EIA, environmental impact assessment. That would be the local wind farm, the Habitats Directive and the Pollution Control Directive. The SEA directive says, which sets the framework. The assessment sets the framework for future planning applications under the EIA Pollution Control and Habitats Directives. The first man up on this was Pat Swords, my friend, an environmental campaigner, a Dublin engineer, and he tried to get into the Irish High Court, and it lasted 2 or 3 years, and they eventually thwarted him. He then tried to get into the European Court of Justice, and it was the procedure leading up to that where he got blocked. Now, we had a fund, and I acted as a fundraiser, and I acted very honourably in that, and there was a lawyer selected out in Europe to get our case into the European Court of Justice on behalf of the European Platform Against Wind Energy, and some way or other they managed to thwart us on our position. What exactly were we? What kind of a body were we? But they did keep us out. Now, I won't exactly say it was the European Court of Justice kept it out. It was the procedure leading up to it and the European Commission that didn't want us in there. Now, so then I took a case on the North-South Interconnector, the pylons, and Judge Max Barrett ruled that Bord Pleanála couldn't refuse it. It had no substantial decision to make. After 42,000 euros in fees being collected by people to support the planning observations and submissions, he ruled they couldn't refuse it. He wasn't going to allow any Cavan farmer to go up, or Monaghan farmer, or any other farmer, and go up and block the whole EirGrid. And EirGrid read out all the wonderful things they were going to do, and he seems to have swallowed it hook, line and sinker. He would not grant it in the High Court. Then I took a cabling case on Ra Wind Farm, and the Bord Pleanála capitulated, but all that meant is they had to do an environmental impact assessment on the cables. They had done one on the wind farm, but they hadn't done it on the cables. And I won that, and I got all my costs and got a nice little bit of money back out of it. Then I had my case on the mast, in where the judge in the High Court ruled a mast attached to Ra Wind Farm. Afterwards, they were moving it, and he ruled that the SCA didn't apply. It was the original one did, but he also ruled that the road that I have and land on and that adjoins the site, it does not need a notice. And if you look up the 2001 Planning and Development Regulations, Article 19, you'll see that it says all entrances. He said no, he wasn't going to let me win that either. Now, the next thing was, away out abroad in Belgium, a local group went to the local court and said the wind energy guidelines of 2026 have never been assessed. You can't use them. Of course, the local court threw it out as well. No, it needn't be coming near us. But they went to the European Court of Justice and they gave the case 2419. See, 2419. Planning applications on the 2006 guidelines that have not been assessed are a planner programme. Any application must be annulled or dismissed and thrown out, and any existing wind farms built on the 2006 guidelines being used must be taken down. And I'm currently in the process of trying to take down Ra Wind Farm, and I noticed that the mast has never been built. So I think that the financial markets are beginning to get the jitters. There's a huge legal issue over 4,000 megawatts of Irish wind farms, and I'd say at least 3,000 megawatts of that was built since 2006, and therefore they can all be taken down. It will all take time. So another event then is that Pat Swords, at the same time roughly as this, he's helping with a case for Sweden and Holland in which the European Investment Bank is being challenged on the right to finance all this energy infrastructure without complying with the SCA directive, and that's going on in the court. And I helped a little bit to get an Irish group is being named, and they're going in, an Irish name going in on observation, and we're still waiting on how that will be received. He's working on that. That's going on there as well. So you see, we're starting to tighten on them. We have come to realise that you needn't be going to the High Court. It's a waste of time. Now, the name of the group that's in on that is People Over Wind. Now, I don't give a damn. I don't like criticising courts or anyone else. We have to have them. But in reality, I mean, we know now. We're beginning to see a pattern emerging. Now, friends of the Irish environment, all for climate change, they want essentially all fossil fuel ended. They want us back to the horse and cart and sitting in the dark. But they mightn't be that extreme, but that's what they are. But isn't it funny that it's an ill wind that blows no good? Because we know from the experience of Germany now with the lockdown that the windmills they have are no good, and it's beginning to dawn on people that they were sold a fraud in this. And you have the choice of people being frozen and dying, or keeping the environment going for 100 years, which I say is a scam. I say that the climate hoax is a hoax. There's no threat to the climate as such at all. And but anyway, they're entitled to do what they want. They want the whole country locked down, but they are not happy with how the government is proceeding. And I want to read you an article. Now they took a case, and I want to read you the article here. And we're on how many minutes? 10 minutes. So I should have time to get this in. Supreme Court. This is the Irish Times article. Supreme Court refers to Europe in the case challenging Project Ireland 40. This is one of Eamon Ryan's and other suckers, Fianna Fáil and Fine Gael, backed on by Sinn Féin to bring out all these grandiose plans, and it's costing 116 billion, and that's only what they got doing in the last couple of years. Give them a few years more, it'll be 700 trillion billion. They just love these throwing away money. The Supreme Court wants the Court of Justice of the EU, that's the top court of the EU, to clarify 3 issues of European environmental law, how it should be interpreted. The 7-judge court, 7 judges in the Supreme Court, the Supreme Court. And don't forget, the Friends of the Irish Environment, they went to a judge of the High Court. I went to 3. I won in 1 by a concede. The board conceded. 2 others ruled against me. Pat Swords got nowhere either. And so they haven't a great record, although they do sometimes find in the case of the EIA directive for individual wind farms. But you go in challenging the whole thing and you've got nowhere up to date, and I don't believe you ever will. And in the case, if these cases are not referred to the commercial court, as happened with me, you can be there arguing your case, and your case is lined up with asylum seekers one side. The last case I had, there was a row of asylum seekers looking to get staying here on one side of me, and ahead of me was a fella that was arrested by the guards for drunken disorderly or doing something else, and he was saying he should get out of jail and all of this. So you find yourself arguing the most complex European law with this other stuff going on, and barristers all arguing with this fella. He hit the guard or he didn't hit him, or the camera wasn't working. This is the ridiculous nature of Irish environmental law. The Supreme Court wants the Court of Justice to interpret the law. The 7 judges agreed in the Supreme Court on Wednesday to make a referral on the Environmental Group's appeal, which seeks to quash the government's 116 billion Project Ireland 240 development programme. You want to see Ryan bragging about this when he goes abroad. Oh. Project Ireland, which comprises the National Planning Framework and the National Development Plan, is the government's long-term strategy for land use. None of this assessed. And development is the long-term strategy for research for land use and development in the country. It was adopted by special cabinet meeting in Sligo in 2018. I'll bet it was, with no assessment whatsoever. The High Court and Court of Appeal previously dismissed claims by the Friends of the Irish Environment that the 2040 project was invalid due to lack of proper environmental assessment and a failure to properly address climate change. So they say it doesn't go far enough, right? FIE, Friends of Irish Environment, represented by Neil Steen, solicitor, and John Kenny, senior counsel. Neil Steen, senior counsel. You have to have a senior counsel and a BL, even on a wind farm case, and a solicitor. And John Kenny, BL, instructed by FP Loeb solicitors, argued in the Supreme Court that the project's adoption should be overturned due to an alleged failure to meet the assessment requirements of the Strategic Environment Assessment Directive, which has been transposed into Irish law in 2004. In particular, FIE contended that reasonable alternatives to the 2040 project have not been sufficiently explored. The directive is clear. You must explore the do-nothing scenario. I have a video on that. And reasonable alternatives. There were 11 forms of energy nominated in the EU's Directive 2009/28 EU in 2009. And they only went for this chronology with the wind and the solar because that's where the money was. And the lobbyists were in making sure, let us build these wind farms. We're mad to pour concrete and steel. We'll flog it onto some pension fund and then now we bail them out. I got a letter there for the farm. I'm getting €200 off the government to help me pay me electricity bill. I mean, this is the corruption you're dealing with, right? The group's case is against the government, the Minister for Planning Ireland, and the Attorney General. Yeah, I'd have had it against the Minister for Energy as well, but the Minister for Planning, anyway, is named, so I think that's all right. The SEA directives aims to ensure environmental considerations are looked at in certain high-level plans and programs adopted by a public authority. I'll bet you the 116 billion is not a high-level plan. This is what I'm going to say. In a ruling on behalf of the court, Mrs. Justice Baker said, this is the Supreme Court now, said a question arose as to whether the national planning framework or the National Development Plan should be considered as plans or programs within the meaning of the SEA directive, and consequently whether they need environmental assessment under the law. And that environmental assessment would have to be with public participation and the right for people like me to take a judicial review, and they know I'll put them through the ringer on that. The state respondents, through their counsel, Fintan Valentine. Now, Fintan Valentine was for the state. They can be either side, and next time they could be on the other side. But anyway, senior counsel submitted that while the framework was assessed for the purposes of the directive, the assessment was not a legal obligation. So we were promised an SEA directive, we voted on the Lisbon Treaty, and now he's telling us it's not a legal obligation at all. Oh, it doesn't matter. Now bear in mind, he's under instructions by the government. He's only saying what he's told to say. So it's not a legal obligation. The National Development Plan, meanwhile, is wholly outside the scope as it is a budgetary policy, it was argued. It's wholly outside the scope. So they can build all of this because it's a budgetary policy, right? In other words, if you were caught in the unlicensed drinking premises, you could say that the government has regulated and taxed alcohol, and you're paying all the tax because you bought it in the wholesalers, or you bought it in the off license. So you don't need a license at all. This is the nature of the corruption of our government. Please understand that. I'll read it again to you. The National Development Plan, meanwhile, is wholly outside the scope of the budgetary policy the government is arguing. Away with that, we don't want to hear that. And I was up at the Chester Beatty Library in Dublin in 2013, and this is what I was told by all the great and the good, and some people slightly on my side. It's soft law. It's soft law. And when we were voting on it, it was hard law. The second concern, the treatment of the plan as a budgetary financial plan, and whether the fact that it was adopted to support the framework means it should be treated as a plan or programme under the directive. So Mrs. Justice Baker said the first question, now she represents 7 members of the Supreme Court, all of who agreed, and 3 at least judges of the High Court, the lower court, have thrown out cases where the citizen tried to claim the SEA directive. 3 of them threw it out, and you would not get barristers nearly to go in free. I had to go in on my own. And here we have Miss Justice Baker, supported by all 6 others and herself, said the first question to be referred to Europe refers to the scope of the directive. There's not a hope of the European Court of Justice ruling against me or the FIE on this, Friends of the Irish Environment. They have already ruled in 2419 that the wind energy guidelines are a plan or programme, and I cannot see them ruling otherwise than a 116 billion project like this is not a plan or programme. It's put forward by the government, big dinners in Sligo and big outfit and big publication. So that's the first question they're asking. 7 judges of the Supreme Court, the highest court in Ireland, said this is important and referred to Europe. And 3 judges in other cases said it doesn't matter who. Why? 3, 4, because the judge in the Friends of the Irish Environment, he or she, whoever it was, ruled against them as well. The second concerns the treatment of plans or as a budgetary and financial plan, and whether the fact that it was adopted to support the framework means it should be treated as a plan or programme under the directive. In other words, do they get away with this baloney of saying it's only budgetary? I mean, what do you do if you give the money to build something? What are you doing only building it? If you give the money to build a bridge over a big river, aren't you actually building it? Oh, this is the corruption of them. The court also wants the EU court to consider whether the reasonable alternatives have to be environmentally assessed at the same level and on the same basis as the preferred option ultimately selected, and whether the level of scrutiny will depend on the stage of the process where that should happen. Must they assess reasonable alternatives? I have no doubt they'll say yes. It's in the directive. You have to assess reasonable alternatives, like retrofitting homes. But they won't want that. There's no money in them. People have to. Tradesmen would make money, not the wind companies. Chief Justice Donald O'Donnell, Mr. Justice John McMiniman, Mr. Justice Susan Dunn, Mr. Justice Peter Carlton, and I was on a course once where he spoke for about an hour and a half, and he's extremely dedicated member of the Supreme Court. It's great that he got. I'm surprised that they let him on it because they're so corrupt, but anyway, he is there. Mr. Justice Isult O'Malley and Mr. Justice Gerard Hogan agreed with Mrs. Baker's judgment. They agreed. So how have we, the Irish High Court judges, refusing country farmers like me, and when it gets to the Supreme Court, the Supreme Court rules on my side. And if I had to go ahead and appeal mine to the Supreme Court, I would have won, but I was on my own, and it's not easy doing it. You need a stenographer. It's very difficult. Now, the crows are coming home to roost. We've already won 2 wind farm cases on 2419. The European Court is the way to go. The Irish Supreme Court seems to be on our side, on the side of justice, not our side. And so it's rapidly becoming clear that in the cases when you're dealing with European law on the SEA, you need to get to the Supreme Court. You will not get justice in the High Court. In the case of ordinary wind farms, yes, you can win on that, surely. And you'd need to be prepared that if you lose on 2419, and you could get a judge in the Irish High Court who would say, oh, 2419 doesn't apply, then you have to go to the Supreme Court. And that would mean, if he did that, or she did that, that Ireland would have a different law to the European Union. The European Union has already made the law. I hope I've made myself clear. The bottom line is the government are up the wall. They're up the wall. They're adjourning wind farm applications. They don't know what to do. They're scrambling around wondering what to do. Where will we get poor communities where we can dump these? So they have to get a poor community and an area where the wind farms can be placed. Where can they get that won't challenge on 2419? And it won't be too long now till we can challenge on this other thing, that they haven't been assessed under the SEA directive. The government has falsely and corruptly went on for 12 years putting these up. And my reading of it is, I and others can make them be pulled down. Don't forget the European Commission on the Derrybrine wind farm, where there was all the peat slighted and there was 50,000 fish, trout killed. It is forcing the government to take down Derrybrine wind farm. And when I get time, if they don't do it soon, I'll go in and I'll take a case making them take it down. But for now, anyhow, we do the best we can. I think that is very, very good news. It's a nil wind that blows no good. Let's see what they do. It could be 9 months before it comes up. I think the government doesn't stand a chance. It was just a matter of getting lawyers to take this case. And lawyers should have acted no foul, no fee. They should have realised this was the way. And why were they so reluctant? It could be that if we shoot down the whole thing, all stops. And their heart really, as they are in the end of the day officers of the court, is in all this wind energy. And it could be that they know they'll kill the goose that lays the golden egg. They want appeals on wind farms, but they don't want to kill the whole project.